Iku Inona. Please rise. Ahea oko e ko ka aha, inake kuliana imua o kea aha ho ko ki ke hano o ko moko aina o Hawaii. Inaoi mai, e malio mai, ilohe ia kaleo. Hear ye, hear ye, hear ye, all persons having any business before this honorable Supreme Court of the State of Hawaii, draw nigh. Give your attention and you shall be heard. Inoho ilalu. Please be seated.
All right, please call the case.
Case number SCAP-23-0000088. State of Hawaii Plaintiff Appellee versus Bernard Brown, Defendant Appellant. Arguing for Appellant Bernard Brown, Randall Hironaka. Arguing for Appellee, State of Hawaii Deputy Prosecuting Attorney Chad Kumagai. Arguing for Amicus Curiae, Attorney General of the State of Hawaii, Deputy Attorney General David Van Acker. Argument on the merits.
All right, good morning, aloha everyone. Our proceeding today is being broadcast live on the Judiciary's YouTube channel as well as on Olelo. Counselor, are you all ready to proceed? All right, we've allocated 45 minutes for each side. Mr. Hironaka, you'll begin with 35 minutes, 10 minutes reserved for rebuttal. Mr. Kumagai, 30 minutes with a 5-minute warning. Mr. Van Acker, 15 minutes with a 2-minute warning. And mahalo to the State of Hawaii for appearing as amicus of the court today. And then again, we'll be back to Mr. Hironaka for his rebuttal. Mr. Hironaka, please proceed.
Thank you. Mr. Chief Justice, members of the court, good morning. Aloha.
Aloha.
It's been a minute since I appeared here. Always a pleasure. Indulge me for just a couple of minutes. Imagine you're in an on-again, off-again relationship. Imagine it's somewhat tempestuous. Your family and friends know it's rocky at times. Your other's family and friends know it's combative at times. And one day, the two of you are in an on-again period, and you're having a good day. You spend an evening together. Maybe one of you makes dinner for the two of you. You watch videos, you laugh, you're intimate. Maybe that intimacy carries over into the shower. And maybe while being intimate, or playing around, she slips. She hits her head, and she dies. And because you know that everyone knows that your relationship can get fiery at times, and if you tell the truth, people may not believe you. You worry about how bad it looks, how bad it makes you look, so you panic. And then you make a series of very bad decisions. You have limited funds, so you try and access her bank records. You use her phone to try and book airline tickets. Maybe you even find a way to dispose of her body. But
Did your client testify?
He did not.
Is this in the record?
I'm sorry?
This is in the record then?
It's in the record. He did not testify.
Okay. And where is it in the record?
That he did not testify?
No, the fact that these facts that you are alleging as to what happened.
I see. I'm speaking hypothetically. And I'll say this. You're not guilty of murder. But the evidence against you looks exactly like the evidence against Bernard Brown. You're not guilty of manslaughter. You're not even guilty of assault. But you displayed a lot of consciousness of guilt in a series of bad decisions. There are many issues in this case, and the issues are interwoven and intertwined with each other. And the one I'd like to start with is sufficiency. You know, normally, as you all know, this is an issue that's kind of thrown into criminal appeals at the end, but it's not a throwaway issue here. Sufficiency of the evidence, or the lack of sufficiency of the evidence, is front and center in this case. And if this court agrees with our position that the evidence is insufficient, then the case doesn't get remanded. It gets reversed, and an acquittal is entered for Mr. Brown. And I realize how big of an ask this is. It's a big case. It's a murder case. But that's why it has to be the 5 of you, because the jury, operating off of emotion, didn't acquit Mr. Brown. Circuit Court judge, with immense small community pressure, didn't grant our numerous motions for judgment of acquittal. But this issue is of a constitutional dimension. It concerns due process, and it concerns a lack of proof beyond a reasonable doubt. Murder as you all know, has two elements. It has a conduct element, and it has a result of conduct element. There has to be proof beyond a reasonable doubt of an act, in other words, something like physical abuse or an omission. And there has to be result of conduct, which is death in this case. And then you need an intentional or knowing state of mind as to each of those elements. So in this case, again, there is a lot of consciousness of guilt. That's what the evidence is in this case. But consciousness of guilt as to what? It does not replace evidence of conduct. And it doesn't replace evidence that there was state of mind as to the result of conduct in this case. There is nothing in the record that can be pointed to say that there's proof beyond a reasonable doubt of an act or an omission or state of mind as to the result of that act. There's an evidentiary problem. And we would ask the court to consider Reeves, which is basically a recent UEMV in the first degree case that involved several defendants basically vandalizing, attacking a car. We cited to this in our brief. And that resulted in a reversal and an acquittal of not just the UEMV 1, but UEMV 2, because there was no evidence that the defendant in that case had any intention to enter the car on that date.
Mr. Hironaka, the problem you're identifying, I guess is set forth in your hypothetical at the beginning of your argument. That would be true of any case in which, pretty much any case in which no body is found, there was no witness to the alleged murder. Isn't it within the province of the jury to look at all this evidence and consider the hypotheticals, the hypothetical you proposed or others, and from the evidence come to the conclusion that the behavior of the defendant was more consistent with a knowing and intentional act of murder as opposed to some less serious or less significant course of conduct? Isn't that within the jury's ability to determine? And if not, how would these kinds of cases ever potentially be made?
So you bring up a great point, and obviously there's no evidence that jurors or any trier of fact can look to determine state of mind. But that would only speak, what you're referring to, that would only speak to proof as to a defendant's state of mind. The problem in this case is it's still not evidence of any conduct or act or omission on the defendant's part. It's also not evidence of state of mind as to what result. And so that's the problem, is that, again, there's a lot of consciousness of guilt evidence that really is only circumstantial evidence of state of mind, but state of mind as to what is missing, as to conduct that is missing.
Couldn't the jury consider whether in their reason and experience a person would go to the lengths and take the steps that Mr. Brown allegedly took in order to cover up an innocent accident in the shower? Can't they make that judgment?
Mr. Chief Justice, respectfully, no. That it would be pure speculation as to the conduct element of the offense. That is, and I realize that's not a popular answer, but that's the law. Is that it is not circumstantial evidence of any conduct on the part of the defendant.
Does your point conflict with one of your points of errors that the court should have given lesser included offenses? It's almost like you're suggesting there should have been a manslaughter, and if that, then all the way down to assault third.
So it can at first glance seem like a conflict, but no. I think our point is that if there's no evidence of murder, then if there's evidence for a jury to find murder, if it survives the JA, then common sense would say that means any other situation, such as recklessly causing death, intentionally assaulting, recklessly assaulting, those would all be in play. So respectfully, it's not in conflict. It basically says that if there's evidence of murder, even without conduct evidence, then you have to give the included offenses as well, because there's obviously evidence of that as I mean, we don't agree that there's evidence, but under this not hypothetical, under the situation that it survives the judgment of acquittal by the court, those instructions needed to have been given. The subpoena issue is a significant one in this case. And, you know, about 11 years ago in 2014, this court correctly predicted that in an ever-increasing digital age, people are required to provide sensitive personal information to access a broad array of necessary services. This court, at the time, Justice McKenna, Chief Justice Rechtenwald were both members of the Walton opinion, had the foresight in recognizing that the providers of those services giving such protected information at the whim of law enforcement, merely filling out a form, i.e. a subpoena, and without judicial oversight, could possibly infringe on one of our most valued and protected constitutional rights, the right that each of us has to be secure in our persons, our property, our personal information. You know, Walton, over the years, has most commonly been cited to as severance.
You know, one of the subpoenas to Hawaiian Telecom, as I saw it, it requested where the decedent was at the time she, I guess, used the ISP, right?
That is correct.
And so in other words, it was like who, because she had accessed various things, like Facebook, or I guess sent email, or I can't remember, but it was, where was she, right? This ISP, where was it? So whose rights to privacy are involved here?
In this case, Mr. Brown's, because that IP address.
So if it had come back that she was at the mall, it would have been the mall's privacy interest at stake there?
Well, I couldn't speak for the mall, but there would be, you know, if there was an individual involved, because we're talking about individual rights, then that would be an argument.
It's like, I'm trying to figure out whose interest, reasonable expectation of privacy is being alleged here.
Mr. Brown's.
Mr. Brower's, because that was his ISP.
That is correct. That was his IP address. Correct. That was the one.
His IP address.
Correct. Correct. So this is more than analogous. This is almost directly on point.
Is it also hers? Like, do we have a reasonable expectation of privacy as to where we are when we are accessing the internet? Like, maybe we don't want people to know that we're on a trip somewhere, or, you know,
sure,
we're at somebody else's house or something, you
sure.
know?
I would answer that yes, but that's not, Mr. Brown wouldn't have standing to make that argument on behalf of, he can only assert his own individual privacy interests. So that's why there was no motion to suppress with respect to the things the police found on her phone. There was no motion to suppress their attempts to get her records, her phone records, her Facebook records. None of that was done because he doesn't have standing.
Right, and is that why you weren't making a claim for privacy interests on behalf of Mr. Brown in the IP address that was found on her phone, right? Or that was related to her phone as far as what she was accessing when she was at Mr. Brown's apartment?
That is exactly correct.
All right. And she was placed at Mr. Brown's apartment through Mr. Brown's own statements, not only to the police, but to other witnesses.
That is correct.
Right? He said she was there from 7 to 10:30, and then he says that she left from there. He wasn't quite sure how, but she had left.
Correct. That's his first statement.
And the records showed that the IP address that she was using was during that time period, on January 12th.
Was during that time period. Correct.
Right. And everyone knows that she was at his house at that time because he said that.
That is correct.
And nobody was contesting that.
That is correct.
And when I looked at the your motion to suppress, I didn't see any real assertion of a subjective, actual expectation of privacy. Was that asserted?
That was basically the crux of the motion. Was that
What did you allege in that? What was the basis? That he had an actual subjective expectation of privacy in his subscriber information.
in the information he provided to Hawaiian Tel? Yes.
Yeah. What did you allege to support that? Subjective, actual expectation.
That was Walton. That was the specifically the there's a lot of language from Walton, but
No, I'm not talking about Walton, and I apologize, I wasn't clear.
oh, sorry.
Walton says we didn't do away with the subjective and objective factors, right?
Correct.
And Walton, both the majority and the dissent said there has to be an actual subjective expectation of privacy.
That is correct.
Okay. What did you assert for that prong in your motion or at the hearing? Because I didn't see anything that jumped out at me.
Well, respectfully, what we asserted or what we alleged was that providing the context in which his information, his subscriber information, was provided, that he had a subjective expectation of privacy in.
Okay, but he never says that. There's no evidence of that. I mean, you're saying it. I understand that. I'm not
Sure.
disputing that, but it's actually got to be provided to the judge
Oh, I
at
see.
the time of the hearing.
You mean from an evidentiary standpoint, like in the form of
Something.
testimony?
There has to be
or-
an actual subjective expectation of privacy.
I-
That's the first prong.
Sure. I guess we were arguing it just based off of common law and a reasonable person's. Would they have a reasonable expectation?
Okay, but
of
you're telling us
privacy?
to follow Walton. Walton says subjective expectation is part of the two-prong test.
Right, and I would argue that Walton also held that in the context of what they were talking about in Walton, which was identifying a member by membership number by providing their name. That was enough for the Supreme Court in Walton, or for that concurring majority. So that was the analogy. It was
Okay, but
basically
can you
the same.
point to anything for the five of us here where you put forth something that exhibited a subjective, actual expectation of privacy in that subscriber information?
I guess only Walton, only by analogizing it to Walton.
Thank you.
Yeah.
You know, I guess what Justice Evans Bates is saying is there's nothing on the record to suggest that Brown, for example, knew that, hey, my when I'm using the computer, that my IP address is going to go out there to all these people. And if there was maybe a VPN or something like that to block that, had he said something like that, would that bolster your reasonable expectation of privacy?
If he had testified and said that specifically, sure.
Because
But
I think that's what Justice Devins is getting at. There's really nothing on the record to show Brown's reasonable subjective expectation of privacy. So it seems like you're sort of just collapsing it all into the objective piece.
Perhaps I am. I mean, because again, I didn't put him on the stand to testify as to his expectation.
And he could have testified at the suppression hearing, or I guess that hearing, and it wouldn't have compromised his right to testify at trial, right? They couldn't use that to impeach him.
I would agree with that.
And let me ask you about this. It just seems that, I mean, when you look at Walton, in Walton, you know, the majority and the concurrence were sort of disputing about the public and the private nature. I mean, that was sort of the big beef on it.
Right.
And I look at that, and I just look at all the case law out there on this issue, and it seems to sort of have a line with respect to content and non-content. In other words, there's, you know, a real objective and even a subjective expectation of privacy in, say, your search histories or your specific emails and texts and all that stuff. And can you explain to me how simply a name, which is not content-based, fits into your constitutional arguments?
Yeah, so that's a great question. That's something I wanted to address. And, you know, this the specific, quote from Walton by the concurring majority is just one sentence. I'll read this. It's one's identity is a gateway to information collected by third persons, some collection occurring without a person's knowledge. Only context can determine whether the disclosure of one's name would be the key that unlocks the door to a protected zone of privacy. So a couple of things to answer your question, Justice Edens, is that, number one, it has to be in context. I think it's, and respectfully, it's an oversimplification to say you don't have a reasonable expectation of privacy in your name. You don't have a reasonable expectation of privacy in your IP address. That should not be the issue or the discussion.
Do we have a reasonable expectation of privacy in our home addresses?
I would say you do.
You think we do? In this day and age?
I think, well, I guess maybe I should amend my answer. It depends. It's what it's tethered to. It's again, it's the context. It's, for example, have you ever Googled your phone number?
I'm sorry?
Have you ever Googled your cell phone number? For some, I mean, would it shock someone if their name appeared in a search result with their phone number? It's I think it depends on the context. It depends on what you're tethering that name or that address or that thing to. And I would point out too that the legislature's own definition under 708-800 of personal information includes a person's name, includes a person's address. But my argument today is that it's the context. It's what.
So if it's context, I mean, you're talking about, okay, let's say a GNC card, context. That doesn't really lead to any content. If the card was maybe, hey, I'm a card-carrying member of the ACLU, or I have a card with a membership ID of the NRA, that would lead to a content-based thing because it's showing some sort of a political, affiliation.
Sure.
Isn't that the difference between that and the Walton situation, and also why Walton said it's really context-based? So sometimes names really matter because they lead to content, but other times, as the prosecution's suggesting here, the name really doesn't lead to any context. You have an extra chain. I understand what you're saying is it unlocks the door. But it just seems that there's a difference here if we're looking at context and name, and you have to look at what we're looking at. So what do you say to that?
So my response to that would be that the IP address, as was pointed out by Justice McKenna, it tied the cell phone, arguably Mr. Brown, to a location. And that's what Carpenter was about, that the context in Carpenter is about location. And I realize that, that can be distinguished.
I thought it was just the name that was associated.
I'm sorry, I'm talking about the U.S. Supreme Court case.
I'm talking about this case.
This case, yes. But
I thought they just gave the name.
I'm analogizing what they did was by putting the name with the IP address, by connecting those two together, they narrowed down a location at a time when Mr. Brown said she had left already.
But he confirmed she was there, and he told others that she was there, and that's how that IP address got tied in. It came off her device, it came off what he was accessing, and then you have the stipulation that he says, hey, by the way, I'm a Hawaiian Tel customer.
So the problem with the searches were that the particularly damaging ones, I'll say, occurred after he said she left. So that's the combination of his statement that should have been suppressed that established a timeline that nobody else could establish because he was the only one with her.
Okay, what about the fact that I assume that it's most of these Wi-Fis are password protected.
Mm-hmm.
She was living there. He gave her access to it because obviously that's what came up in the evidence. Isn't that some sort of waiver? Does that cut against the reasonable or subjective or objective expectation of privacy? Because he already gave it out. And they get it off her phone, and then he says, hey, by the way, I'm a Hawaiian Tel customer. And I think looking up who the carrier isn't that difficult in this day and age. Can't you just run an IP address and it'll tell you who the provider is?
I think you might be conflating him allowing her to use his Wi-Fi, which yes, on her phone would reveal the IP address, but would not reveal who that IP address belongs to. So when law enforcement came in, bypassed the search warrant requirement, and obtained that information from Hawaiian Tel, that's when it became a problem. That's
Well,
when
wasn't that hard to deduce because they knew it wasn't a T-Mobile managed IP address, right? And she was with T-Mobile.
Well, again, the IP address is assigned by the internet service provider. So,
Right.
for example, here, Hawaiian Tel, Spectrum, different from your wireless carrier.
Right, and they knew the number was connected with Hawaiian Tel.
You mean her phone number?
No, the IP address. That's
The
in
IP address.
question. We knew that was a Hawaiian Tel provider.
That was the Hawaiian Tel
Right.
provider, correct?
And then he says, I'm with Hawaiian Tel, him being Brown.
That was established via the subpoena.
Didn't he basically give it up at that point?
I don't think he said that. It
Well, he
was
stipulated to it.
well, what we stipulated to was that about a year after they sent a subpoena to Hawaiian Tel for his.
No, it was during trial. Instead of calling the Hawaiian Tel representative, you guys stipulated and said Brown was a customer.
Right. Well,
He was a client.
what we were stipulating to was that the result of the subpoena returned his IP address, but the stipulation was because a year later, the MPD, Maui Police Department, had sent another subpoena duces tecum to Hawaiian Tel asking for the same information. For some reason, they asked for it twice, and then a different, that was the Kelly's Mini Mart. There was a convenience store that came back as the assigned subscriber.
Okay, what I read in the record, though, it was a concession that he was the Hawaiian Tel customer.
It was that they both basically, because it was a stipulation because of the evidentiary issue. But even that stipulation at trial wouldn't resolve the pretrial problem. It wouldn't resolve the Fourth Amendment.
So you're arguing that you preserved the issue by filing the motion to suppress.
That's correct.
Um,
And
I'm just curious, so basically what you're arguing is that anytime law enforcement seeks an IP address, they need a search warrant.
I actually am not saying that. I'm saying that when it impacts a defendant's privacy.
But how do they
interests-
know it impacts the defendant? That's what I'm saying. Like, what if she had gone somewhere else?
So that's a great question, and what I would point to in this
So
case.
whose expectation of privacy are we dealing with? But she's passed away, so
Right.
Right.
We're still dealing with his, and a very important point that I think maybe got bypassed in the briefing is this: if you look at the docket 372 is the actual motion to suppress that I filed in the circuit court, and it has a chart that lays out all of the search warrants and subpoenas that were obtained by law enforcement in this case. So Ms. Monsalve went missing January 12, 2014. Mr. Brown's statement, first statement that we're seeking to suppress was January 14th. 2 months later, in March 19th, the first thing that MPD did as far as the search warrant or subpoena duces tecum was they issued a search warrant. They had a lengthy affidavit. It was about 10 or 12 pages. And it was a search warrant for both Mr. Bernard's phone records as well as Ms. Monsalve's. So they showed every ability to comply with the Fourth Amendment. They knew exactly what they were asking for and why.
he was already a suspect. They were already identifying him as at least
That's
a
correct.
person of interest at that point.
That's correct. And the subpoena came 3 months later in June for Hawaiian Tel. So
But so isn't this how law enforcement does like child pornography investigations when they seek the IP address, the location of where the child porn is being disseminated from, and they do it via subpoenas rather than search warrants?
Sure. Apologies. I couldn't necessarily speak to that. I just will say this, is that there's no statute that trumps the Constitution.
Right. So the issue is whether there's a reasonable expectation of privacy and
Correct.
whether
And then the Fourth
a
Amendment.
search warrant is required.
Right.
But you're saying a search warrant is not always required.
I guess what I'm saying is it depends on the thing that's trying to be acquired, whether or not the defendant has standing, number one, has a reasonable expectation of privacy. I agree with that. But that's why the attack on the statute wasn't whether it was constitutional or not. It was that the process, in this case, required to comply with the Fourth Amendment, a search warrant.
Counsel, how does HRS 803-47.6 impact the objective expectation of privacy?
So I know that Mr. Van Acker made a point in his brief that basically by the legislature enacting that statute and allowing ISPs to provide subscriber information, that somehow that operates as an interpretation that therefore people must not have a reasonable expectation of privacy.
Or at least it reflects the societal expectation.
Right, and I disagree. I would.
Okay, why do you disagree?
Because the legislature can't establish or not establish or waive privacy interests or what constitutes a reasonable expectation of privacy. There's nobody that can say that other than, well, I shouldn't say other than the person, but they simply don't. They can't do that on behalf of all of society.
803-47.6, that follows the federal statute, right?
It mirrors a federal statute,
Right.
And
Electronic Communications Privacy Act.
right, and
wasn't the state of Hawaii mandated to enact a similar type statute by the feds?
I would say no, because the states are free to, as Hawaii does often, afford greater protection to its citizens. And I will say this too, with respect to returning back to Carpenter, that involved what was called the Stored Communications Act, which, if you look at it, and it's in different forms now because of Carpenter, which was 2018, it actually reads like an almost higher standard than probable cause. But the U.S. Supreme Court in that case said it still doesn't comply. You still have to comply with the Fourth Amendment and get a warrant. So, as much as this statute that the Attorney General's office in the state, the 803-47.6, might say, hey, this is enacted by the legislature, it doesn't.
Okay, but at the end of the day, you agree it's a case-by-case context determination, right?
Sure.
As far as the degree of expectation of privacy.
Sure.
Thank you.
Mr. Hironaka.
Yes.
So in Walton, although the court spent a great deal of time addressing the Article 1, Section 7 privacy rights with regards to a GNC card, right. There,
Right.
and linking the identity of the person who owned that or that card was assigned to. Ultimately, the court held in that case that whatever, in terms of the violation, was harmless error because other evidence placed that defendant at the time of the crime, right, in the location.
At the scene.
My question is to you, in this case, what we're dealing with is simply whether that IP address and the identification of Mr. Brown as the customer for that IP address, the assigned customer, was proper or not. Now, the question I have is, wasn't that already established by other evidence?
So yes and no. So I'm not trying to be cagey, but this part, your question needs to be considered in the context of that statement that he made, that first statement, the only one that the circuit court did not suppress. Because again, as I was telling Justice Devins, his statement established a timeline. That the short version of it is we were hanging out that night, and then she left sometime around 10 p.m. And then when her phone was recovered and the SIM card was recovered from the dumpster and it was analyzed, then that's when these kind of funky searches were discovered on her phone after 10 p.m. And so law enforcement, realizing that these searches looked bad and believing that it established at a minimum some kind of consciousness of guilt, they wanted to know where that phone was when it made those searches, because it was after a time that Mr. Brown said she had left.
I understand the consequences of
Sure.
that, of the linking up of the identity
Sure.
to the IP address. My question is, wasn't his identity already linked up to that IP address by other means, i.e. His Facebook use, the other search warrant information that was obtained?
Oh, I see. No. It was established by the subpoena deuces taken.
The only basis for establishing his identity with that IP address is the information via the subpoena to Hawaiian Telecom.
Pre-trial, correct. Correct.
All right.
Would you like to address the issue of prosecutorial misconduct and the use of "we know" during the closing?
Sure. So again, this is our belief is that Browder is directly on point with this, both the ICA opinion as well as the Supreme Court opinion, this court's opinion in Browder.
Well, the Supreme Court's opinion in Browder didn't touch the we know from the ICA.
Correct. So
be clear on that.
Yeah, sorry. So it's really, I guess, the ICA opinion, which went, as you pointed out, Justice Evans, undisturbed. It wasn't expressing our personal opinion. It invited the jury to share in that opinion. It was used multiple times during closing by both of the prosecutors who gave the primary closing as well as the rebuttal closing. Most importantly, it was tethered to the other issues that the state was weak on. It was tethered to everything we've been talking about thus far, to where was the phone when the searches occurred, what were the searches for. It's tethered to sufficiency of the evidence, Mr. Brown's statement, establishing a timeline, and it was also the owner of the IP address. So it made it particularly harmful that they were, the state knew it was weak. Their case was, in my opinion, not even built on circumstantial evidence because, again, there was zero evidence of conduct, zero evidence of state of mind as to result of conduct. And so that's why the prosecutor kept repeating, we know. It was expressing personal opinion about the strength of the case, about the evidence itself, and it was designed to get the jury to share in that opinion and to jump on board with it.
And that was all done during rebuttal where the defense had no really opportunity to kind of counterweigh those comments.
That's correct.
Sometimes lawyers, defense counsel too, will get up there and argue we know, sort of the collective we know based on the testimony and the evidence. Am I hearing what you just said is basically in this particular case on those comments, and I'm talking more about the rebuttal comments, that because the prosecutor did not sort of link it up like we all know through the testimony or we all knew, we all heard the evidence in there, had that been done, that would not necessarily have suggested the we meant the police department, the prosecutors, the state, the government.
Correct.
Is that pretty much your point there?
Yes.
Let me ask you, switching gears a little bit to the custodial interrogation part. Do you contend at some point during the police questioning that probable cause arose at some point to then require the reading of the Miranda rights?
Yes, and I think that was...
And then the next question, when, where?
Right. So our position is that, and I know it's not necessarily tied to page length, but that first statement was, in the neighborhood of 20 pages. There was about the first 3 pages had to do with Mr. Brown's personal info, his physical attributes, questions about his relationship and the history with Ms. Monsalvi, the circumstances and timing of when he last saw her. All of the rest of the questions, he was asked if he physically abused her in the past, asked if the police ever were called to the house for any domestics or any type of incident, if he had ever been arrested, for what reason, if he knew where she was now. The detective repeated that the family...
But how is that? That would be probable cause to charge somebody?
Not
arrest somebody?
Oh, I see your question. Not necessarily that there'd be probable cause to charge, but Ketchum and Hewitt, the point is that he's being subjected to sustained and coercive questioning, which required the warning and waiver if it was to continue.
But didn't the questioning kind of stray back and forth between asking him about his knowledge or where he was versus her drinking habits, her other associations, other information, the totality of which seemed to indicate the police were attempting to identify and just assess a very, very recent report of a missing person?
Yeah, respectfully, I think a couple of those questions were mixed in there, but I think it would be difficult for anybody here to disagree that when they're repeating accusatorial questions, such as, again, describing his relationship with her, including moving out, and did you have anything to do to harm her, to have her disappear, they're trying to see if he's going to change his answer.
I can see, that the one I'm going to ask you again, did you have anything to do to harm her? I mean, that possibly could be an area where it gets a little more coercive. But I want to ask you about the again. He said, I'm going to ask you again. I didn't see anything in the transcript of him asking that before. Is there any suggestion on the record that before there was recording that he was asking Brown whether he had harmed her?
I don't recall any evidence of any, pre-recording questioning. He may have been referring to his own questions with respect to if he physically abused her in the past, if he knew where she was now, and referring to the family, thinking he has something to do with it.
Okay,
So,
thank you for that context.
Sure.
You went up a little bit over your 35 minutes. Unless there's another question at this time, would you like to keep your time for rebuttal?
Please.
All right.
Thank you.
Thank you very much. All right, Mr. Kumagai, you're on.
Mr. Chief Justice, Associate Justices, may it please the Court, Deputy Prosecuting Attorney Chad Kumagai for Plaintiff Appellee State of Hawaii. Your Honors, this appeal raises important issues with respect to homicide cases where the victim's body is not recovered. In cases such as this, it may be impossible to determine the defendant's specific actions that caused the victim's death. Yet, according to the appellant's arguments, the prosecution would nonetheless be required to allege and prove exactly this, effectively preventing the prosecution of murders when a body is not recovered. Adopting the appellant's arguments would prevent the prosecution from holding murderers accountable and incentivize them to dispose of their victims' bodies to avoid prosecution when they would otherwise be found guilty beyond a reasonable doubt. Today, I ask this court to preserve the state's ability to prosecute homicide cases without a body and affirm the circuit court's judgment of conviction. I welcome the court's questions.
Why wouldn't there be a reasonable expectation of privacy in one's IP address?
Well, I think to focus the court's attention on this, the privacy interest that I interpret and I see from the record is linking Mr. Brown's name to that IP address, not necessarily the IP address.
Did you have the emails from him, Bernard Brown, gmail.com or whatever, with the IP address before you issued that subpoena?
I'm not entirely sure about that, but I know that the IP address that was ultimately linked to Mr. Brown came from the complainant's phone and the records in her phone. And then I think from there, the police...
You didn't have his emails also?
Not to my knowledge, and if they were, I don't think that they came into evidence. There was a lot of Facebook activity that came into evidence, but I'm not aware of any...
Oh, I see. So, okay.
Yes.
At the motion for suppression, I think Mr. Hironaka clarified he wasn't asserting a privacy interest in the IP address itself. It was in the attachment to Mr. Brown's name. Isn't that what he clarified?
Correct.
Because I think Mr. Kagami thought it was the IP address and the clarification was made. It's not the IP address, it's the connection.
Correct.
Right. Thank you.
Yes.
So that's not an issue before us, right? The IP address privacy interest attached to that.
No, it's not.
All right.
Yes. So if the court would like me to continue on about that, I think that Mr. Hironaka is right, that context matters when we're assessing whether there's a privacy interest. And in this case, I submit to the court that the defense...
Well, Walton says context matters.
Correct.
It mandates that.
Correct.
Case by case.
Correct. And in this case, the appellant did not provide any context other than what was already provided at the hearing through the testimony of the detective. So the appellant has not demonstrated either a subjective or objective reasonable expectation of privacy as to his name associated with that IP address. And so therefore, Walton doesn't create a privacy interest in of itself.
Would it have been different if he had a VPN?
I think that would be something that the court could consider. I think that's a step to make his IP address more private, and consequently his association with his IP address from the ISP.
But doesn't that then mark a big difference in privacy between the tech-savvy individual and the one who's not tech-savvy? I mean, you could, most people might not understand that they're broadcasting this information out, but hey, the person who has a little bit of computer acumen does. I mean, I don't see where you can draw the difference there.
Well, I certainly agree with that, Justice Edens, that what may be subjective to some may not be to others. And I think that's why it was imperative for the appellant to put on evidence at the hearing of the motion to suppress in order to assert that subjective expectation of privacy, which he did not do. And so I submit to the court that based on this record, there is nothing to indicate that the defendant had a subjective expectation of privacy. And so we don't even get to that objective prong.
And I guess, okay, putting that aside, to, I guess, give up your right to privacy. I open the door so everybody can see inside, or I whatever. I mean, it seems like you have to understand that what you're doing by opening the door. You see what I mean? Is somebody who doesn't know what they're doing in opening the door or sending out, the Facebook or whatever they're doing. I'm just wondering how they can, how somebody can really waive something that they don't even know exists, is what it kind of boils down to.
Well, and I think that's why it would have been important to hear any type of evidence to that effect. For all we know, Mr. Brown is incredibly tech savvy, or maybe he's not. I don't know. There's no evidence to that effect.
So, and I'm sorry, I might have cut off a little bit of your answer to Justice McKenna on say somebody who was tech savvy. You might have a different slant. What would be your position be if Brown had got up there and said, "Hey, look, he understood everything." In other words,
agreed. And I think that's why context matters. That's why.
But that goes to subjective expectation, doesn't it?
Correct.
Well, what did they know? What did they think?
Yes.
That's all we're talking about.
Yes. And I think there's a grave defect in the appellant's argument in that respect.
Because he could have said, I had no idea my IP address was being broadcast in that manner.
He
I
could
didn't know
have.
anything about it.
He absolutely could
I
have.
had my name on my email address, but I didn't know anything beyond that.
Yes.
That would have been a subjective expectation.
That would have probably established a subjective expectation.
so then getting the objective, what's your position on 803-47.6? Justice Devins had some questions suggesting that means that here that's an objective expectation of privacy built into both the federal and the state statutes.
I'm sorry, could you repeat that?
Okay, so 83-47.6, which I actually see as more of a content protection statute, but essentially the position is that and the federal act do sort of support an objective expectation.
Perhaps as to content, which I don't think that we're dealing with here. To me, we're dealing with pure subscriber information, just answering the question, who is the subscriber?
Okay, and I'm sorry, I wasn't really clear. I guess what I mean is the statute does suggest there's no objective expectation of privacy.
Oh, I'm sorry, you're saying the opposite.
Yes.
Yes, so I agree with that, and I think that there are cases around the country, Mr. Vernacker would probably know better than me, but there are cases around the country that say that an ECPA, like the one we have, like the federal statute, does provide some notice that certain information may be disclosed.
And what's your position about Mr. Hironaka's position that it's sort of an as-applied unconstitutional argument, it seems, with respect to 83-47.6?
Well, I would disagree with that. I mean, I think even if we were to import the Constitution into that analysis, we would still have to do the reasonable expectation of privacy test to determine whether or not there's a search of constitutional magnitude. And as I stated here, there's nothing to indicate that.
Do you see that statute as actually a protective statute that protects content?
I do. I think that is very broadly, because there's always room for context and specific cases. But I think very broadly, the line should be drawn at subscriber information versus content. Content, of course, reveals much more intimate details of life, whereas subscriber information doesn't.
Wasn't this link, having the name linked with that account, wasn't that critical to being able to argue that it was him who was searching these various airline records during the course of the night? And isn't that like starting to get into content, because we're, I guess, assessing where he went, what was going through his head, what he might have been doing. Why would he be making reservations or assessing various credit cards as well as flight information? I'm not sure the line between content and non-content is as clear in this case as you seem to think it is.
Well, I think that the bank information, the flight records, all of those things that were searched or found on the complainant's phone were not a product of that subpoena, which was very limited to asking who owns this IP address for this limited period of time. All of the evidence.
Wasn't the argument he was the one who was doing all that?
Yes.
Okay, and the reason the prosecution was able to make that argument was because this was his account, correct? Or he was the person who had the IP address which was used.
Ultimately, but the content that we're talking about, the bank records, the flight records, all of that, those weren't obtained pursuant to the subpoena. They were obtained through the phone that was found in the dumpster a quarter mile from the...
Right, but the critical link that linked it to him was the fact that he was a subscriber to that IP address, correct?
That's a link in the chain, yes, but I looking strictly at what was presented to this court by the appellant, that was the subpoena to Hawaiian Telcom and the appellant's name associated with that.
Is an IP address like a street address?
I think that some may draw an analogy to that in the sense that, it's kind of like receiving mail, right? Where
If you have someone's street address, like in Honolulu, can you figure out whose home it is? Who owns the home?
I think generally, yes. I mean, there's open source intelligence now. If
Honolulu property search through
Correct.
the city's website.
Bureau of
If
Conveyances,
you know the street
yes.
address, you can figure out who owns the home, not necessarily who lives there, because maybe it's an absentee landlord or maybe it's rented.
Correct. Yes, I agree with that.
Can I ask you about the January 14th interview
Yes.
that Mr. Brown went in on?
Yes.
What I tried to look at was the information that the police had leading up to that interview, and it seems like they did gather up quite a bit of information, and they already had some inconsistencies. They had some suspicions conveyed to them by not only family but also coworkers, and said this is completely out of step with what she normally does. She never misses work, or if she does, she calls in. They also had the information that Brown had said that the son Tyson had come to pick her up, and Tyson said that never happened. So you had some information that did point to Mr. Brown as at least a suspect. Would you agree with that or disagree?
I'll acknowledge that there was some evidence in that direction. I don't think that all of the facts that you mentioned were known to the police.
Well, that's what the police report indicated. that was all gathered up in a matter of a few hours. The daughter came in to make the missing person report. I'm sorry, didn't come in, but she was off island, but she called in. And she relayed that, Brown had said that the son had picked her up. The son said no. And then they interviewed the son. So they had that in hand going into the interview.
I would say even if they had that evidence, that is insufficient to establish probable cause. I don't think that's enough to make an arrest for Mr. Brown. There was a litany of evidence that the police did not know at that time, including everything that was in the dumpster, everything that was on the phone, many of the conversations that were discovered later about, selling furniture and his car and moving out of the house and the story about the cat. All of those things I think were discovered afterwards. And those are really I would say, more key pieces of evidence. It is important that, the complainant was at Mr. Brown's house without question. But I think without that, there wasn't probable cause. probable cause came later.
But, you know, it seemed to be a pretty direct and probing question when you got to about the 22 minutes into the interview where they said, hey, did you do anything to harm her, cause her to disappear? I mean, isn't that getting up to the line?
So, you know, I cannot defend those questions. I wouldn't counsel the police to ask them, and I don't know what the expected answer was supposed to be. But the standard here is whether or not the defendant had been implicitly or explicitly accused of a crime, because
his
the
reaction
question
in his voice inflection sounded very defensive.
Well,
he was being accused.
Well, it was. The standard is whether or not the defendant was implicitly or explicitly accused of a crime because the questioning had become sustained and coercive. And with respect to that later portion in the interview where I think Justice Devins you're referring to, where he sort of seems to get a little more upset, the detective tells him, you know, if I thought that you had something to do with this, we would have a different conversation. He calmed him down by telling him, at least implicitly, that he didn't think.
Well, I think that's more calm him down to talk more. Don't you think?
No, I disagree with that. The last question that was asked to Mr. Brown was whether or not the complainant was blackout drunk. It wasn't anything about whether or not Mr. Brown had anything to do with this. And, you know, I think listening.
Well, I mean, there was almost back-to-back comments about the thing about, you know, I'm going to ask you again, did you have anything to do with harmer? And then he kind of follows that up with, hey, look, the family kind of thinks you got something to do with it.
I see that as an explanation that the detective is saying, this is why I'm asking you these questions, because the family thinks you may have something to do with it, so I want to dispel that. And that's why I'm asking the questions.
Do you think that was exactly what was going through the detective's mind, or was the detective trying to gain this person's trust?
I don't know what was going through the detective's mind.
Didn't we have a case from Kauai, and I can't remember the name of the case, but the idea of, you know, the detective sort of ingratiating himself to the defendant. Hey, we had that case involving your daughter a couple years ago, and you remember, you know, I treated you folks fair. So this is a little bit isn't there an element of that here? Hey, if I thought you had something to do with it, this would be really a different conversation. He's trying to get his guard down.
I think even under that interpretation of the statement, I don't think that the interview rises to the level of being sustained and coercive. Listening to the actual audio of the interview, this is not a fast-paced, sort of dynamic interview. It's more slow and plodding than sustained and coercive.
But in the very beginning, he already asked, did you have anything to do with, her not being here anymore? And he said no. So why do you come back to it?
I think the second time that he asked about it, he cleared up the timeline because he kind of did calculations going backwards.
The initial question was, did you do anything to her? It was an open-ended question. He says no.
Right.
That's it. Why did they come back to it again? They didn't read rights. They come back. I'm going to ask you again. Did you harm her? Cause her to disappear? Because pretty pointed questions.
I think that the second time it was asked was to clear up the timeline as far as the dates. The detective is talking about, well, today's the 14th, so that means the 12th was Sunday. The third time, as I
regardless of timeline, he's asking, did you harm her? Did you cause her to disappear? I don't see the relevance to a timeline. He's asking point-blank questions. Did you do something to her? But he already asked that in the beginning.
Right.
He said no.
Well, like I said, I would say that does not rise to the level of sustained and coercive when those questions are
not coercive when you get an answer no and you've already answered that and you come back later.
Now when those questions are mixed in with things like, has she ever done this before? Was she suicidal?
You're in a police station with two detectives and you're in the interview room.
I think when they're in plain clothes and the defendant willingly comes to the station and is able to leave right after, a half-an-hour interview is not something that should be considered custody.
I don't think I saw anything that said that he was told at the interview he was free to leave at any time.
I don't think that was explicitly stated, but he was able to leave after the interview was done. There was and one thing I want to mention, with respect to anything that might have allegedly occurred before, the parties stipulated that there was no conversation between the defendant and the
Right,
police.
and the interview doesn't start with, now you're here voluntarily, you're free to leave at any time.
Right. But I don't think that's
You're not required to answer my questions.
I don't think that's a condition precedent when the police are investigating a missing persons case. There's no probable cause, and the questions have not become.
But the missing persons, I mean, touching upon what some of the things that Justice Evans was just asking you, it is a little bit different phrasing here. Did you have anything to do with harm her versus, I'm going to ask you again, do you know where she is? This is a missing person cases. There's a difference between asking where she is, maybe you have any, versus did you do anything to harm her? I guess your point is probably, it seems, that it's just not sustained.
I wouldn't say, I don't think it is coercive either, given the entire context of the interview, where the defendant feels comfortable enough to talk about the pizza that he ate and the movie that they watched and how bad it was. And, like I said, listening to the actual audio of the interview reveals that this wasn't like a pressing interview. Even when the detective asked, did you have anything to do with her disappearance? Did you harm her?
Have you ever been arrested?
I'm sorry?
Have you ever been arrested?
I think even then, the questions weren't posed in a way that should be interpreted as coercive or overbearing or anything like that.
Did he ask to leave at any time or ask to take a break?
The
During the
defendant
interview?
did not. And
Yeah, I'm sorry, I'm asking about Mr. Brown.
correct. He did not. And this interview was 30 minutes from start to finish.
Now,
Yes.
coercive and all, the jargon we use there, it's really all designed to prevent involuntary confessions, right? I mean, what's your position on whether this was a voluntary statement or not?
I think it was entirely voluntary because the defendant showed up to the police station after he was asked on the phone. It's not as if the police came to his house and tried to escort him there. He willingly came to the police department. The detectives were dressed in plain clothes. They went up to an interview room, which I don't think in of itself indicates that there's anything wrong with talking to the police. And I think most importantly, as I said, the fact that these questions are interspersed with all these other questions, these investigatory questions about where the complainant could have been, is very telling and about the context and the tenor of the interview.
Can I ask you one more? Can you address the we know
Yes.
situation? You heard the questions I asked the softball question I asked Mr. Hironaka. Can you respond to that?
Yes, so I think that the we know is, I understand the court's concern with it, but I think in this case, in the context in which it was used, it didn't have any effect on this case. And the reason is, when it was used, all of the discussion was based on evidence that was presented, evidence that was largely uncontroverted, and the defense objected several times throughout the closing to other arguments. It did not object to the use of the pronoun. And I think that shows that even the defense didn't really see that as something that was unduly swaying the jury. And like I wrote in my brief, the Conroy's use of we know is entirely different from this case. In Conroy, the we knows were accompanied by things that would make Socrates blush. I mean, it was so outrageous that it's just not comparable to this case.
Well, I think you analogized it in your briefing to it didn't really go to an element. You're not saying it has to go to an element, though, do you?
No, I'm not saying that, but in Browder it did, and that was the way that I was.
The
discussing.
ICA's Browder.
Correct. The ICA's unpublished opinion in Browder.
It
Correct.
was that the state did not take cert on.
Correct.
Yes.
Yes. Right. So, if I may touch on the sufficiency of the indictment, I think that this court's decision in State v. Tran sort of takes care of that issue. There, the sufficiency of the indictment was not raised until after verdict, which this court said triggered the moral Wells presumption. And under that presumption, the prosecution was not required to allege more than the statutory elements. And I think that's the same case here, where under the moral Wells standard, the prosecution was not required to allege the specific means by which the defendant caused the death. And further, I think, you know, as I said earlier, these types of homicide cases where body is not recovered sort of stand alone in the world of criminal prosecution, in the sense that a lot of times we're not going to know what the exact method of causing the death was, and what the, oftentimes even when there is a body, we don't know what the exact cause of death was, or what specific punch slash whatever you want to say caused the death. And I think that's acknowledged in other states that have passed statutes that say that the prosecution does not need to allege in the indictment the specific manner of causing the death. Those states are Mississippi, Michigan, Nebraska, and West Virginia.
Do you think that as of June 19th, June of 2014, the state did have probable cause at that point to believe that Mr. Brown had something to do with the victim's disappearance, the person's disappearance, Ms. Monsalve's disappearance?
Well, no, I don't think so. I think that the investigation went on for a number of years. It included the cast analysis, which outlined...
You were getting search warrants in March and April of 2014.
Right.
Just wondering why you didn't get a search warrant here instead of doing a subpoena.
Well, I think because the subpoena was sufficient and a search warrant wasn't required for that Hawaiian Telecom information. I'm sorry, is that your question?
I mean, you had a pretty good sense that that IP address was a...
That may be so, but again, a search warrant was just not required under our constitutional rules, given the lack of a reasonable expectation of privacy.
Did the police really have to know who the IP address was assigned to? Didn't they have enough through other evidence that established the connection between that IP address, that physical location, Mr. Brown and Ms. Monsalve?
I agree with that. I think that there was a lot of evidence that indicated that Ms. Monsalve...
Didn't really matter at the end, did it? As to who was assigned to it, as opposed to who was using it.
Well, I don't think that the information obtained by the subpoena indicates who was using that IP address.
No, I'm saying it was more important as to who was using the IP address during certain time periods.
Right.
That was the critical evidence.
Right.
Not so much who was actually assigned to.
Correct.
And everybody knew where Mr. Brown lived, right?
Right.
And they knew it was an IP address relating to Wi-Fi. So there had to be a router somewhere nearby.
And he had also told other people that the complainant was at his house, you know, separate and apart from that IP address and any digital evidence.
Understood. Thank you.
I'm going to follow up on that. So
Yes.
The state had Facebook information. Did any of that, through a search warrant, did any of that Facebook information in any way connect the IP address to Mr. Brown? I thought there was some officer testimony along that line.
I'm sorry, could you repeat that?
Was there any information other than the Hawaiian Telecom information through the subpoena, other than that, was there any other evidence connecting Mr. Brown to that IP address, his identity to that IP address?
At least the fact that it appears he attempted to book a flight on the complainant's phone, which was linked to his house.
How does that identify him with the IP address?
I think that the jury could have made a reasonable inference from that Mr. Brown was the one using the phone to book the flight.
Because that effort to book a flight included his name for booking that flight.
Yes, correct. And that phone was linked to his house.
And
through
linked
the
to that
IP
IP address.
Correct. Yes.
Right. Wasn't his Facebook also in his name?
His Facebook was also in his name. Yes, that's correct.
So that identifies him.
Correct. Yes. If the court doesn't have any other questions, I ask the court to maintain the prosecution's ability to prosecute these types of cases where no body is recovered, and I ask the court to affirm the judgment. Thank you.
All right. Thank you, Mr. Kumagai. Mr. Van Ack.
Mr. Chief Justice, and may it please the court, there is no reasonable expectation of privacy in internet service provider subscriber information under either the federal or our state constitution. HRS section 803-47.6 adequately safeguards Hawaii citizens' privacy rights by drawing a clear line between non-content subscriber information, which can be obtained via subpoena, and the content of communications, which can only be obtained by way of search warrant. Subpoenas serve a critical role in investigations throughout the country. They are often at the height of their utility at the initial stages of complex investigations before probable cause has materialized. The Attorney General respectfully asks this court to follow other jurisdictions that have squarely addressed this issue and to hold that ISP subscriber information can be constitutionally compelled by way of an investigatory subpoena under HRS section 28-2.5 sub B. I welcome the court's questions.
Well, you're no fan favorite of Walton, according to your amicus brief. But don't the factors in Walton support the prosecution's position here?
They sure do. I absolutely agree. I think factors 1, 2, and 5, the subjective expectation of privacy, the intimate details of a person's life, as well as an individual's sense of security, all weigh in favor of no reasonable expectation of privacy. And respectfully, Justice Edens, we take the position that Walton was an important deviation from the third-party doctrine. Honestly, I think Walton was ahead of the curve. It's 4 years pre-Carpenter. We understand the sensitivities behind that opinion. Our perspective is more along the lines of, in doing away with the third-party doctrine, the court abandoned the principle that is the linchpin of investigations throughout the country. It did not specifically indicate how it would impact investigatory subpoenas, and to that end, Walton specifically acknowledges it is an experiment. We look at this conversation as a natural extension of that experiment, where we can explore the extent to which the government can use subpoenas to further criminal investigations.
So I guess what I'm hearing you saying is you don't really like Walton, but it works. I mean, if it's all context-based and even content-based, Walton's framework doesn't really compromise things. I mean, is the AGs and law enforcement in this state actually over scared of Walton? I mean, it sounds like you haven't pressed it. It's like, well, there's no case law because, but it seems like you're like overly frightened by Walton.
Justice Edens, I think there's a real avenue for that logic. Potentially law enforcement overread the reach of Walton and has been tiptoeing around it in a way that frustrated the majority opinion's desire to have a laboratory of democracy.
Let me ask you about your proposed two-step. Explain that second step.
Sure. Again, Walton proposed this novel and experimental approach. There are states like ours that indicate that their constitution is more protective than the federal constitution. Some of those states, Illinois, New Jersey, Washington, Florida, then do this kind of balancing between the law enforcement need for that particular type of service. I would suggest that the court gives nothing away by doing that second step balancing. It would still be free to tailor our Constitution as it saw fit. It's just a method, I think, to build a better record and to establish law enforcement need at the trial.
Isn't your second step just really an objective expectation test? Well, what does society accept? We're going to balance law enforcement needs against privacy interests. I mean, it's just an objective test, isn't it? At the end of the day,
I think that's
really something new.
I think that is a totally reasonable way to look at that, Justice.
Okay, and with Walton, the way I understood it to be, and I wasn't on the court back then in 2014, but it was just saying that, third-party disclosure isn't an automatic waiver of privacy rights. We're going to apply the same test. What was so new about that?
I think it's, I honestly, I agree with you once again. I do look at the holding in Walton to be simply a more articulate rendition of Katz. So I don't know that it was the sea change that maybe the government has thought in the 10 years henceforth.
Thank you.
Well,
So what exactly is law enforcement scared of? What about the Walton test is causing them to hold back?
I think it's exactly the point that I articulated, Mr. Chief Justice, which the fact is that subpoena practice has relied on the third-party doctrine. And so in the absence of the third-party doctrine, the state of subpoena practice is quite uncertain. And I'm not suggesting that the third-party doctrine, just to re-articulate, is a good solution. I don't believe it adequately protects our citizens' rights. I do think it needs to be a case-by-case analysis. But I just think it's important for the court to know that complex investigations, oftentimes around the country, are built using investigatory subpoenas.
Well, Walton, the majority in Walton said, doesn't mean that you can't get that information. You just need to seek a search warrant. What's the pragmatic difficulty with that?
Sure, the pragmatic difficulty is that there are investigations, specifically complex investigations, let's say money laundering, for instance, in which the entire rationale behind the criminal conduct is obfuscation and concealment. And so I think a subpoena is a method through which to sort of follow that type of activity, honestly, in an instance where probable cause hasn't germinated.
I mean, that's one area. I mean, it sounds like you're articulating a problem that's much larger than that.
I'm not sure exactly what you mean by that remark, but I think that, as I've said, doing away with the third-party doctrine and providing, in our view, not a lot of room for subpoena practice moving forward, that's really had the chilling effect that we're talking about in our papers.
Do you draw sort of the line that Mr. Kumagai was drawing, and maybe to a certain extent Mr. Hironoko was drawing? It's all about content. I mean, isn't that the big distinction between a subpoena and a search warrant?
I think that's consistent with the position laid out in our papers, I believe. And I also think that is consistent with Walton itself, if we look at the intimate details of a person's life, if we look at jeopardizing an individual's sense of personal freedom, I think that could be a line that this court draws in those circumstances.
Seems to be also the line that the statute drew, didn't it?
There's no doubt about that. It's a very explicit line that the legislature drew. And to your point, Justice Edens, that statute was designed to safeguard citizens.
But it also made the exception to what's been referred to as basic subscriber information.
Yes.
803.
Correct. And we think that dovetails with the Walton factors quite nicely.
All right.
Thank you
Thank
so
you very
much
much for appearing
on
today.
behalf of the Attorney General, and it's been an honor arguing with and against my colleagues.
All right. Thank you, Mr. Van Acker. Mr. Hironaka, your rebuttal.
Thank you. Okay, so just a couple of quick points. First, Mr. Chief Justice, I think the case you were referring to about ingratiating, I believe that was Trink.
Yep, that's right. Thank you.
And so, and I would, well, I'm not sure if you're saying this, but if you are, I would agree with you that there was ingratiating going on during that interview with respect to some of these questions. I would also respond to Mr. Kumagai's argument that, that my client was asked to come to the police department over the phone, but, to the point where if he's not really a suspect, if he's not going to be subjected to coercive questioning, then why not have that interview over the phone as well? I want to point out something important is that the subpoena ducis tecum that we're talking about in this case only has a reference to the subpoena ducis tecum statute, which is HRS 28-2.5. There were no arguments advanced below. There was nothing on the subpoena ducis tecum that in any way, shape, or form references 803-47.6. So I understand going forward what the court's opinion in this case may affect, ISP or telecommunications practice or acquiring information or investigations going forward. But with respect to Mr. Brown's case, we are very clearly talking about that other statute, that 28.
Well, but doesn't that other statute, look at CAHEA, it's pretty broad. It gives the Attorney General pretty darn broad discretion to subpoena documents and information, doesn't it?
It does, which is my point, is that all it requires is a showing of that it be material and relevant to the investigation. But again, what we know about, no pun intended, what we know about the police's investigation at the time that they issued this subpoena, they had already done search warrants. He was already a suspect.
Speaking of CAHEA, I mean, they were getting into financial records, and the court said that was okay.
Right.
And that seemed a lot more intrusive than asking about someone's name on an IP address that you already have developed.
And I do want to address a couple of things there. I think we'd be remiss to ignore the fact that Walton was about a GNC membership number, and it was about basically subscriber or member information, and we're talking about GNC. So to Justice Eden's point, they were the court, or the concurring majority anyway, was so concerned about that for.
But it's a membership number that's not published or broadcast,
Right.
which is much different than an IP address. I don't see them being, it's apples and oranges to me.
I did want to address something that you asked Mr. Kumagai about with respect to the Facebook records. The Facebook records were not used or in any way, shape, or form did not ID or associate Mr. Brown with an IP address.
Well, I
At least,
believe a detective testified to it at trial.
but it wasn't. It was the subpoena ducis tecum that established the identification and the context and the link to the IP address. They did not do it through
I'll take a look at
Facebook.
it again, but I thought it was the Facebook records that they'd obtained that established that IP address. But I'll take a look at it again.
So my understanding is that there was a search warrant that was issued for his particular Facebook
Right.
records, right? But as to specifically the link and the association between the IP address and Mr. Brown, that only came via the subpoena ducis tecum to Hawaiian Tel.
But the Facebook was in his name, though, that he was posting to.
The Facebook was in his name, but there was
Right.
no talk about the IP address with respect to the Facebook records.
But
It was
the
just
search warrant disclosed that IP address, the same one, when they looked at the Facebook records.
It-
He was using that IP address to access his Facebook. Is that correct?
That I'm sorry, I don't have a memory of that, but all I know is that the way they linked the IP address for the searches on Ms. Monsalvi's phone to Mr. Brown was only via Hawaiian Tel. They didn't connect multiple dots.
Oh, I
to the
understand
Facebook
that's how
record.
they got the assignment.
Sure.
It was assigned to
Right.
him. Yeah, I understand.
Okay.
Thank you.
Okay.
I'm sorry if I.
No. And, I wanted to not to return to the sufficiency argument, but, I certainly understand on a human level what Mr. Kumagai's arguments are with respect to, missing body cases, the difficulty in prosecuting them. But, on the flip side of that are cases where people get wrongfully convicted.
I'm sorry, could you repeat that?
They're on the flip side of that is these are the types of cases that result in wrongful convictions. Recently we've had exonerations in the Dana Ireland case. And so the danger in what Mr. Kumagai is talking about is basically it's not just litigating, it's letting it go to juries, a trier of facts based upon emotion, based upon things that are not evidentiary based. What I'm proposing, what I'm talking about, the challenges to what happened in the circuit court level have to do with the evidence. It has to do with the sufficiency of the evidence. I understand why he's making that argument. I'm certainly sympathetic, but it doesn't carry the day with respect to the law.
Counsel, I'm sorry. Can I go back to Kahea?
Sure.
How do you square that where they use 28-2.25 to get bank records, financial statements, which to me is very sensitive.
Sure.
And this court said that was okay. And now we're just talking about IP addresses and names, which seem a lot less sensitive.
Sure. I guess my argument to that would be that, Walton came after that, and obviously the law is ever evolving, in a digital age such as what we're talking about. The other argument I didn't get to.
Kahea was 2021.
Oh, I'm sorry. Okay, but
it was 2014.
I think your difference, Mr. Hernako, would be one is a civil case, one is a criminal case.
Right. I'm sorry. Yeah, that's correct. So it's and respectfully, what I was also going to say, as far as an analogy with respect to this case, is that it's analogous to a person's movements, which was the concern in Carpenter. So,
but does a civil and criminal case affect a person's expectation of privacy? Does that change? Is it a different standard? Does it depend on what kind of case or underlying allegations are made now?
I apologize. I'm unfamiliar with what kind of constitutional challenges get raised in civil court, but in criminal court, we are talking about individual rights and squarely putting this with the Fourth Amendment, which was the concern in Walton.
Thank you.
Yes.
All right, Mr. Hironaka, anything further for the court at this point? I want to give you a moment to wrap up your argument if you'd like.
I did also want to address, I don't know if the court's willing to kind of go back to the included offense instructions and the Arceo issue. I know that wasn't really addressed with Mr. Kumagai, so it's not necessarily rebuttal.
What a very brief argument on that point.
Very briefly. Again, the point here is that there is, if there is sufficient evidence for murder as charged, then there is for all of its included offenses, arguably. And there's a rational basis, arguably. I know that, the state has taken issue with our saying, well, it's not this sort of endless array of possibilities, but it actually is. That's sort of the point with the included offenses and with the way that this case is charged, with the way the issues are intertwined. And so the jury, if it was going to survive, they should have been given the included offense instructions. And with respect to Arceo, this is I guess for lack of a better term, in any acts case, it's not a multiple acts case because no acts were alleged or presented to the jury. But any acts, I would say, is analogous to multiple acts. And so that's why, to ensure a unanimous verdict, that Arceo instruction needed to be given as to all the offenses, included or otherwise. And then the last thing I wanted to say was Mr. Kumagai said that the subscriber info was just a link in the chain with respect to the ID and with respect to the IP address. It wasn't a link in the chain. It was the entire chain. Mr. Brown's first statement to the police coupled with the information obtained from Hawaiian Tel via subpoena ducis tecum, those are both required to make the state's case. That was essentially the state's case at trial. So either one of them being suppressed or being inadmissible would result in harmful error.
Very well. Thank you to all of our attorneys for your arguments here today. The court will take this matter under advice.
E ku iluna, please rise. Ua ho'o ku'u ia mai nei, kea aha ho'o kolo ki ike hanahano o komoku ana o Hawaii. This Honorable Supreme Court of the State of Hawaii is now adjourned.